Good morning. Today we have Blind Children is the title. Jury charge, you have 190 to 220. Let me give you some words that come out. You have Pam and Dick Little, Alan Ebert, MD, Bruce Wood, MD, Gerald Munch, MD, Pain and Suffering, Extraordinary, Capabilities, Commencement, Educational, Paul Little, Incapable, Parental, Conclusive, Medical, Majority. And this is going to be 190 for 5 minutes. Members of the jury, in further determining the loss suffered by the plaintiffs, you should take into consideration any extraordinary expenses incurred in the past and which you find will be incurred in the future by the Littles as a result of the birth of Paul Little under emancipation or otherwise. Extraordinary medical and educational expenses are those medical and educational expenses incurred as a result of Paul Little's blindness only. They do not include the costs of raising a healthy child. A minor child is emancipated when he has been freed from parental care, custody, and control. There is a presumption that upon the attainment of age 18, the person is presumed to possess the physical and mental capabilities to support himself, to establish his own residence, and in general to manage his own affairs. Under normal circumstances, parents have no legal obligation to support their children beyond the age of 18. If a child is physically or mentally incapable of self-support when he attains the age of majority, emancipation does not occur and the duty of parental support continues for the duration of the child's disability. At the commencement of this trial, plaintiffs Pam and Dick Little both had a life expectancy of 45.4 years. This expectancy is taken from the tables of life expectancy, which are part of the state law. This table of life expectancy is not conclusive, but may be considered together with all other evidence as to health, habits, and occupation of plaintiffs. You are instructed to answer the following questions. You must unanimously agree upon your answers to each question for which an answer is required. 1. Did the plaintiffs Pam and Dick Little incur any injuries, damages, or losses? 2. Was the defendant Alan Ebert, MD, negligent? 3. Was the negligence, if any, of the defendant Alan Ebert, MD, a cause of any of the plaintiff's claimed injuries, damages, or losses? 4. Was the defendant Bruce Wood, MD, negligent? 5. Was the negligence, if any, of the defendant Bruce Wood, MD, a cause of any of the plaintiff's claimed injuries or damages or losses? 6. Was the defendant Gerald Munch, MD, negligent? 7. Was the negligence, if any, of the defendant Gerald Munch, MD, a cause of any of the plaintiff's claimed injuries or damages or losses? If you find that the plaintiffs Pam and Dick Little did not incur injuries or damages or losses, or if you find that none of the defendants were negligent or that no defendant's negligence was a cause of any of the plaintiff's claimed injuries or damages or losses, then your forewoman shall complete only special verdict form A, and she and all jurors will sign it. On the other hand, if you find that the plaintiffs did incur injuries or damages or losses, and you further find that one or more of the defendants was negligent and that such negligence was a cause of any of the plaintiff's claimed injuries or damages or losses, then on special verdict form B, you shall answer questions 1 through 7 as well as the following, and your forewoman shall complete only special verdict form B, and she and all jurors will sign it. 8. Were the plaintiffs Pam and Dick Little negligent? 9. Was the negligence, if any, of the plaintiffs a cause of their own claimed injuries or damages or losses? 10. State the amount of the plaintiffs Pam and Dick Little injuries or damages or losses for extraordinary medical and educational expenses associated with Paul Little's blindness until he is emancipated or otherwise, which were caused by the negligence of any one or more of the defendants, whether or not such injuries and damages or losses were also caused by the negligence, if any, of the plaintiffs. 11. State the amount of plaintiffs Pam and Dick Little injuries or damages or losses for the effect on their lives associated with Paul Little's blindness, which was caused by the negligence of any one or more of the defendants, whether or not such injuries or damages or losses were also caused by the negligence, if any, of the plaintiffs, less the benefit to the plaintiffs as a result of Paul Little's birth. 12. Answer this question only if you answered yes to both number 8 and 9. Taking as 100% the combined negligence of all parties you find were negligent and whose negligence was a cause of any of the plaintiffs Pam and Dick Little injuries or damages or losses, what percentage of negligence, if any, was that of the defendant Alan Ebert, MD, of the defendant Bruce Wood, MD, of the defendant Gerald Munch, MD, and the plaintiffs Pam and Dick Little? Remember, you must enter the figure of 0 for any party you decide was not negligent, or whose negligence you decide was not a cause of any of the plaintiff's damages. If under the court's instruction you should find the plaintiffs are entitled to a verdict, you will award them such sum as under all of the circumstances of the case may be just compensation for the loss suffered by them by reason of Paul Little's birth. In determining their loss, you should take into consideration the nature and extent of the injuries incurred before trial, any pain and mental pain and suffering, and loss of enjoyment of life endured before trial in this case. If you find that as a result of the defendant's negligence, the plaintiffs will probably endure or incur in the future mental pain and suffering and loss of enjoyment of life, then you shall take into consideration these matters in determining damages insofar as such items have been. Good morning, Cynthia.
Good morning.
Any questions on any of the words right there?
Do you have anything for pain and suffering?
Puffering. P for the pain, uffer, G. P-U-F-R-G for pain and suffering. Anything else? Think of the P for the pain, the uffering for the suffering. Just add in and. Any other ones, Cynthia?
No.
No?
Mm-mm.
Okay, and this is going to be, and this is a little tough, 200. Members of the jury, in further determining the loss suffered by the plaintiffs, you should take into consideration any extraordinary expenses incurred in the past and which you find will be incurred in the future by the Littles as a result of the birth of Paul Little until emancipation or otherwise. Extraordinary medical and educational expenses are those medical and educational expenses incurred as a result of Paul Little's blindness only. They do not include the cost of raising a healthy child. A minor child is emancipated when he has been freed from parental care, custody, and control. There is a presumption that upon the attainment of age 18, the person is presumed to possess the physical and mental capabilities to support himself, to establish his own residence, and in general to manage his own affairs. Under normal circumstances, parents have no legal obligation to support their children beyond the age of 18. If a child is physically or mentally incapable of self-support when he attains the age of majority, emancipation does not occur, and the duty of parental support continues for the duration of the child's disability. At the commencement of this trial, plaintiffs Pam and Dick Little both had a life expectancy of 45.4 years. This expectancy is taken from the tables of life expectancy, which are part of the state law. This table of life expectancy is not conclusive, but may be considered together with all other evidence as to health, habits, and occupation of plaintiffs. You are instructed to answer the following questions. You must unanimously agree upon your answers to each question for which an answer is required. 1. Did the plaintiffs Pam and Dick Little incur any injuries, damages, or losses? 2. Was the defendant Alan Ebert, MD, negligent? 3. Was the negligence, if any, of the defendant Alan Ebert, MD, a cause of any of the plaintiffs' claimed injuries, damages, or losses? 4. Was the defendant Bruce Wood, MD, negligent? 5. Was the negligence, if any, of the defendant Bruce Wood, MD, a cause of any of the plaintiff's claimed injuries or damages or losses? 6. Was the defendant Gerald Munch, MD, negligent? 7. Was the negligence, if any, of the defendant Gerald Munch, MD, a cause of any of the plaintiff's claimed injuries or damages or losses? If you find that the plaintiffs Pam and Dick Little did not incur injuries or damages or losses, or if you find that none of the defendants were negligent, or that no defendant's negligence was a cause of any of the plaintiff's claimed injuries or damages or losses, then your forewoman shall complete only special verdict form A, and she and all jurors will sign it. On the other hand, if you find that the plaintiffs did incur injuries or damages or losses, and you further find that one or more of the defendants was negligent and that such negligence was a cause of any of the plaintiffs' claimed injuries or damages or losses, then on special verdict form B, you shall answer questions 1 through 7 as well as the following. And your forewoman shall complete only special verdict form B, and she and all jurors will sign it. 8. Were the plaintiffs Pam and Dick Little negligent? 9. Was the negligence, if any, of the plaintiffs a cause of their own claimed injuries or damages or losses? 10. State the amount of the plaintiffs Pam and Dick Little injuries or damages or losses for extraordinary medical and educational expenses associated with Paul Little's blindness until he is emancipated or otherwise, which were caused by the negligence of any one or more of the defendants, whether or not such injuries or damages or losses were also caused by the negligence, if any, of the plaintiffs. 11. State the amount of plaintiffs Pam and Dick Little injuries or damages or losses for the effect of their lives associated with Paul Little's blindness, which was caused by the negligence of any one or more of the defendants, whether or not such injuries or damages or losses were also caused by the negligence, if any, of the plaintiffs. less the benefit to the plaintiffs as a result of Paul Little's birth. 12. Answer this question only if you answered yes to both number 8 and 9. Taking as 100% the combined negligence of all parties you find were negligent and whose negligence was a cause of any of the plaintiffs, Pam and Dick Little, injuries or damages or losses, what percentage of negligence, if any, was that of the defendant Alan Ebert, MD, of the defendant Bruce Wood, MD, of the defendant Gerald Munch, MD, and the plaintiffs Pam and Dick Little? Remember, you must enter the figure of 0 for any party you decide was not negligent or whose negligence you decide was not a cause of any of the plaintiff's damages. If under the court's instruction you should find the plaintiffs are entitled to a verdict, you will award them such sum as, under all of the circumstances of the case, may be just compensation for the loss suffered by them by reason of Paul Little's birth. In determining their loss, you should take into consideration the nature and extent of the injuries incurred before trial, any mental pain and suffering, and loss of enjoyment of life endured before trial in this case. If you find that as a result of the defendant's negligence, the plaintiffs will probably endure or incur in the future medical pain and suffering and loss of enjoyment of life, then you shall take into consideration these matters in determining damages insofar as such items have been proved by the evidence. Further, you are to offset any award for the above elements or damages with any benefit plaintiffs have received or will receive in the future from the Comfort Society and protection of Paul Little. Anything there, Cynthia?
No. Mm-mm.
No.
That one is tough.
Very. And so negligent, remember you can write it 2 ways, or any GT, any JT, they both come out. Extraordinary, 3 strokes. On the other hand, OER and V, unanimously is NAMS-ly, unanimous is NAMS. Expectancy is expect-ancy. Established, blish. Anything, Cynthia? Emancipation is emancipation. And this is going to be at 210. Very hard. Members of the jury, in further determining the loss suffered by the plaintiffs, you should take into consideration any extraordinary expenses incurred in the past and which you find will be incurred in the future by the Littles as a result of the birth of Paul Little until emancipation or otherwise. Extraordinary medical and educational expenses are those medical and educational expenses incurred as a result of Paul Little's blindness only. They do not include the costs of raising a healthy child. A minor child is emancipated when he has been freed from parental care, custody, and control. There is a presumption that upon the attainment of age 18, the person is presumed to possess the physical and mental capabilities to support himself, to establish his own residence, and in general to manage his own affairs. Under normal circumstances, parents have no legal obligation to support their children beyond the age of 18. If a child is physically or mentally incapable of self-support when he attains the age of majority, emancipation does not occur and the duty of parental support continues for the duration of the child's disability. At the commencement of this trial, plaintiffs Pam and Dick Little both had a life expectancy of 45.4 years. This expectancy is taken from the tables of life expectancy, which are part of the state law. This table of life expectancy is not conclusive, but may be considered together with all other evidence as to health, habits, and occupation of plaintiffs. You are instructed to answer the following questions. You must unanimously agree upon your answers to each question for which an answer is required. 1. Did the plaintiffs Pam and Dick Little incur any injuries, damages, or losses? 2. Was the defendant Alan Ebert, MD, negligent? 3. Was the negligence, if any, of the defendant Alan Ebert, MD, a cause of any of the plaintiffs' claimed injuries, damages, or losses? 4. Was the defendant Bruce Wood, MD, negligent? 5. Was the negligence, if any, of the defendant Bruce Wood, MD, a cause of any of the plaintiffs' claimed injuries, damages, or losses? 6. Was the defendant Gerald Munch, MD, negligent? 7. Was the negligence, if any, of the defendant Gerald Munch, MD, a cause of any of the plaintiffs' claimed injuries or damages or losses? If you find that the plaintiffs Pam and Dick Little did not incur injuries or damages or losses, or if you find that none of the defendants were negligent, or that no defendant's negligence was a cause of any of the plaintiffs' claimed injuries or damages or losses, then your forewoman shall complete only special verdict form A, and she and all jurors will sign it. On the other hand, if you find that the plaintiffs did incur injuries or damages or losses, and you further find that one or more of the defendants was negligent and that such negligence was a cause of any of the plaintiffs' claimed injuries or damages or losses, then on special verdict form B, you shall answer questions 1 through 7 as well as the following, and your forewoman shall complete only special verdict form B, and she and all jurors will sign it. 8. Were the plaintiffs Pam and Dick Little negligent? 9. Was the negligence, if any, of the plaintiffs a cause of their own claimed injuries or damages or losses? 10. State the amount of the plaintiffs Pam and Dick Little injuries or damages or losses for extraordinary medical and educational expenses associated with Paul Little's blindness until he is emancipated or otherwise, which were caused by the negligence of any one or more of the defendants, whether or not such injuries or damages or losses were also caused by the negligence, if any, of the plaintiffs. 11. State the amount of plaintiffs Pam and Dick Little injuries or damages or losses for the effect on their lives associated with Paul Little's blindness, which caused by the negligence of any one or more of the defendants, whether or not such injuries or damages or losses were also caused by the negligence, if any, of the plaintiffs, less the benefit to the plaintiffs as a result of Paul Little's birth. 12. Answer this question only if you answered yes to both number 8 and 9. Taking as 100% the combined negligence of all parties you find were negligent and whose negligence was a cause of any of the plaintiffs, Pam and Dick Little, injuries or damages or losses, what percentage of negligence, if any, was that of the defendant, Ellen Ebert, MD, of the defendant, Bruce Wood, MD, of the defendant, Gerald Munch, MD, and the plaintiffs, Pam and Dick Little. Remember, you must enter the figure of 0 for any party you decide was not negligent or whose negligence you decide was not a cause of any of the plaintiff's damages. If under the court's instruction you should find the plaintiffs are entitled to a verdict, then you will award such sum as under all of the circumstances of the case may be just compensation for the loss suffered by them by reason of Paul Little's birth. In determining their loss, you should take into consideration the nature and extent of the injuries incurred before trial, any mental pain and suffering and loss of enjoyment of life endured before trial in this case. If you find that as a result of the defendant's negligence, the plaintiffs will probably endure or incur in the future mental pain and suffering and loss of enjoyment of life, then you shall take into consideration these matters in determining damages insofar as such items have been proved by the evidence. Further, you are to offset any award for the above elements or damages with any benefit plaintiffs have received or will receive in the future from the Comfort Society and protection of Paul Little. Anything there, Cynthia?
No.
No? Okay, and so this will be for readback at 200, okay?
Okay.
Members of the jury, in further determining the loss suffered by the plaintiffs, you should take into consideration any extraordinary expenses incurred in the past and which you find will be incurred in the future by the Littles as a result of the birth of Paul Little until emancipation or otherwise. Extraordinary medical and educational expenses are those medical and educational expenses incurred as a result of Paul Little's blindness only. They do not include the costs of raising a healthy child. A minor child is emancipated when he has been freed from parental care, custody, and control. There is and I'm ready when you are.
Okay, members of the jury, in further determining the loss suffered by the plaintiffs, you should take into consideration an extraordinary expenses. Oh, any extraordinary expenses incurred in the past as a result of Paul.
Okay, and which you find will be incurred in the future by the Littles as a result of the birth of Paul Little.
Paul Little until is it in
emancipation?
Emancipation.
Or otherwise.
Or otherwise extraordinary expenses.
Okay, medical and educational expenses.
Are those medical and, you already said that.
No, that's it. Educational expenses are those?
Are those medical and educational expenses considered as a result of Paul Little's blindness only?
Okay, instead of
Blindness.
considered, it was incurred. Incurred.
As a result of Paul Little's blindness, only they do not
Which is
include the cost of raising a healthy child. And then I have a freed from
okay. A minor child is emancipated when he has been freed from.
parental care, custody, and control. And then I have there is.
Good. So I'm going to go up to 220, Cynthia. Are you going to stay for the mock or not? Are you going to
No.
log off? No? Okay.
And log
Let
off
me-
for the mock.
Okay, let me go up to 220. This is 220. Members of the jury, in further determining the loss suffered by the plaintiffs, you should take into consideration any extraordinary expenses incurred in the past and which you find will be incurred in the future by the Littles as a result of the birth of Paul Little until emancipation or otherwise. Extraordinary medical and educational expenses are those medical and educational expenses incurred as a result of Paul Little's blindness only. They do not include the costs of raising a healthy child. A minor child is emancipated when he has been freed from parental care, custody, and control. There is a presumption that upon the attainment of age 18, the person is presumed to possess the physical and mental capabilities to support himself, to establish his own residence, and in general to manage his own affairs. Under normal circumstances, parents have no legal obligation to support their children beyond the age of 18. If a child is physically or mentally incapable of self-support when he attains the age of majority, emancipation does not occur and the duty of parental support continues for the duration of the child's disability. At the commencement of this trial, plaintiffs Pam and Dick Little both had a life expectancy of 45.4 years. This expectancy is taken from the tables of life expectancy, which are part of the state law. This table of life expectancy is not conclusive, but may be considered together with all other evidence as to health habits and occupation of plaintiffs. You are instructed to answer the following questions. You must unanimously agree upon your answers to each question for which an answer is requested. 1. Did the plaintiffs Pam and Dick Little incur any injuries, damages, or losses? 2. Was the defendant Alan Ebert, MD, negligent? 3. Was the negligence, if any, of the defendant Alan Ebert, MD, a cause of any of the plaintiffs' claimed injuries, damages, or losses? 4. Was the defendant Bruce Wood, MD, negligent? 5. Was the negligence, if any, of the defendant Bruce Wood, MD, a cause of any of the plaintiffs' claimed injuries or damages or losses? 6. Was the defendant Gerald Munch, MD, negligent? 7. Was the negligence, if any, of the defendant Gerald Munch, MD, a cause of any of the plaintiffs' claimed injuries or damages or losses? If you find that the plaintiffs Pam and Dick Little did not incur injuries or damages or losses, or if you find that none of the defendants were negligent or that no defendant's negligence was a cause of any of plaintiff's claimed injuries or damages or losses, then your forewoman shall complete only special verdict form A and she and all jurors will sign it. On the other hand, if you find that the plaintiffs did incur injuries or damages or losses, and you further find that one or more of the defendants was negligent and that such negligence was a cause of any of the plaintiffs' claimed injuries or damages or losses, then on special verdict form B, you shall answer questions 1 through 7 as well as the following, and your forewoman shall complete only special verdict form B, and she and all jurors will sign it. 8. Were the plaintiffs Pam and Dick Little negligent? 9. Was the negligence, if any, of the plaintiffs a cause of their own claimed injuries or damages or losses? 10. State the amount of the plaintiffs Pam and Dick Little injuries or damages or losses for extraordinary medical and educational expenses associated with Paul Little's blindness until he is emancipated or otherwise, which were caused by the negligence of any one or more of the defendants, whether or not such injuries or damages or losses were also incurred by the negligence, if any, of the plaintiffs. 11. State the amount of plaintiffs Pam and Dick Little injuries or damages or losses for the effect on their lives associated with Paul Little's blindness, which was caused by the negligence of any one or more of the defendants, whether or not such injuries or damages or losses were also caused by the negligence, if any, of the plaintiffs, less the benefit to the plaintiffs as a result of Paul Little's birth. 12. Answer this question only if you answered yes to both number 8 and 9. Taking as 100% the combined negligence of all the parties you find were negligent and whose negligence was a cause of any of the plaintiffs Pam and Dick Little injuries or damages or losses, what percentage of negligence, if any, was that of the defendant Alan Ebert, MD, of the defendant Bruce Wood, MD, of the defendant Gerald Munch, MD, and the plaintiffs Pam and Dick Little, Remember, you must enter the figure of 0 for any party you decide was not negligent or whose negligence you decide was not a cause of any of the plaintiff's damages. If under the court's instruction you should find the plaintiffs are entitled to a verdict, you will award them such sum as, under all of the circumstances of the case, may be just compensation for the loss suffered by them by reason of Paul Little's birth. In determining their loss, you should take into consideration the nature and extent of the injuries incurred before trial, any mental pain and suffering and loss of enjoyment of life endured before trial in this case. If you find that as a result of the defendant's negligence, the plaintiffs will probably endure or incur in the future mental pain and suffering and loss of enjoyment of life, then you shall take into consideration these matters in determining damages insofar as such items have been proved by the evidence. Further, you are to offset any award for the above elements or damages with any benefit plaintiffs have received or will receive in the future from the Comfort Society and protection of Paul Little. Okay, and so now we'll get ready for the mock. Are you going to log off, Cynthia?
I'm logging off.
Okay, have a great
Have a good weekend.
Okay. Okay, this is going to be 1 minute at 180 lit for warm up before your mock. The primary victims of domestic violence, most often women and their children, need safe places to go for short periods of time so they can make plans either to begin new lives or to return to their homes to work out their interspousal problems. Many of these women also need counseling and other assistance to help them make the transition out of the family or to help them return to their homes. The physically abused woman is not the only victim of violence. The person inflicting pain and misery is the other victim. This person, most often the husband, needs help in understanding why he takes his tensions and aggressions out on his loved one so that he can control this behavior. Help for both victims of domestic violence will make it possible for husbands and wives to restore domestic tranquility. This in turn will rescue marriages that may otherwise have failed and save countless families along the way. While I would like to be able to report that the people of my own state have not experienced family violence, this simply is not the case. A recently formed statewide coalition on family violence and sexual. And then we have on your 180 lit, Jamaica, Ms. Grenemere, Annie, and Ms. Chen. Let me make sure there aren't any others. Mommy is in quotes, okay? This is going to be your 180 lit for 5 minutes for your mock. Judge, I really don't have a schedule that is difficult to understand here. I mean, it's pretty much the same old things that everyone else does with their kids when they are at home with them. Day in and day out, it's just the regular stuff. We are at home and the kids come over and we play with them. Sometimes we play outside and sometimes we play on the computer or play a board game together. I always fix them a good lunch or dinner depending on the time of day they are with me or if they are with me for the night or a weekend. Then Jamaica comes to pick them up and there they go. If he really does have an affidavit from Ms. Grenemere, I have no idea why she would state that I only see them once a month when it's her that drops them off here every morning. The fact that my dad took a week off and is there now at home watching the kids so I can be here is important to note. My parents love the kids also, and they spend a lot of time with them when they are with me at my house. But it's not a lie when I tell you that they are with me from morning to night when they are with me. I don't see them as often during the school year because they are in school all day, but I will go and pick them up from school on Friday and take them back to school on Monday, once or twice a month. Our court order doesn't even come close to what our living situation is, Judge. We have worked it out between ourselves, and Ms. Grenemere was not involved in the process. It was worked out between him and me because they are our children. He kept my son from me all of 2014. He hogs him most of the time. Then he kept my daughter from me all of last year in spite of the court order stating that we are to share her. He wouldn't let me see her. He says that anytime I come out, I can see her. But just last year, he said in a statement to this court that I would have to get some kind of supervised visitation if I did come out to see her. Now, today, all of a sudden, he's saying that I can see her whenever I want. He isn't telling you the truth, Judge. I know for a fact that part of his argument is that he keeps trying to bring up that there is something wrong with me. And he likes to imply that I am mentally ill. He says when he lived with me and the kids that I was unstable when I left with them and that he saw me leaving the house the night I left. He says he didn't see me load up the car, so he didn't even know that I had Annie with me. He says that he followed me all through town in the middle of the night and he doesn't know where she is at. If I was as crazy as he says I am, she could have been alone in the house for all he knew. He never once stopped to check it out. He already had Miss Chen on retainer and he was hoping I would leave so he could do what he did. He ran out right away and got with Jamaica and got an attorney and filled out all of the paperwork. I found out a whole bunch of other things from people about all that later on. All I want is for my daughter to be with me during the school year. If he wants her all summer or for all the holidays, well, that isn't as important to me. They are just days. Having such limited time with my kids, I've learned that they are just days, and any day that I get to be with them is precious. Annie is my daughter. I gave birth to her, and I miss her terribly. I would never try to keep her away from her dad, and I never have done that. I am her mother, and her other sisters are with me, and my parents have a very active role in their lives. If she ends up out here for the majority of the time, we won't get to see her much. She won't have the same family ties out here as she has at home with me. I know in my heart that it just won't happen. I know what he is really like. He doesn't even try to have any kind of relationship with me. If I call there, he lets me talk to her, but he has her call Jamaica mommy. When I asked him why she wasn't being corrected on that, he said it was because Annie knows the difference and he shouldn't have to stop and tell her who her mom is. Jamaica is not her mother. She may take good care of Annie, but she isn't her mother. It was my idea to do every 3 months because I didn't have the money to get out here every other month, but it just isn't working for me. And so Annie was in there, so capitalize it. It is in your proper names. And then now we'll get ready for your 1-minute jury charge practice. This is 1 minute at 200. A person is under the influence of an intoxicating substance when, as a result of drinking liquor or using a drug, the physical or mental abilities are impaired so that the ability to drive a vehicle with the utmost caution that is characteristic of a sober person of ordinary prudence is no longer present. The proximate cause of an injury is a cause which occurs in natural and continuous sequence and produces the injury. In order to prove the commission of the crime of a violation of section 14.5.25 of the Vehicle Code of the State of Nebraska, each of the following elements must be proved: that a person drove a vehicle while under the influence of intoxicating liquor, of a drug, or under the combined influence of intoxicating liquor and a drug, and that when so driving, such person did violate the law or failed to perform some duty required by law, and lastly, that as a proximate result of the violation of a law or the failure to perform a duty, another person was injured or killed. The defendant has violated that law, and that is what he is being charged with in this. And then you have on your 200 jury charge, none. It says no proper names. Let Let me make sure. I'm not seeing any, okay? This is going to be 200 jury charge for your mock with no proper names for 5 minutes, okay? Good morning, ladies and gentlemen of the jury. Before beginning the trial in which you have been sworn as jurors, I would like to address a few preliminary remarks to you pertaining to the issues in this case. You have now been sworn as jurors, and all 12 of you have been selected to be judges of the facts in this case. You have been chosen to do so by both the accused in this case and the prosecution. You are responsible for the determination of the facts. It is your duty to consider the facts in this case without bias, sympathy, prejudice, or passion for either side. I am responsible for charging you as to the law, and in that regard, what I say is binding on you here. It is also my duty to ensure that this trial is conducted in accord with the present principles of law in this state. If the occasion arises for me to make a decision as to the admission of certain facts, you may be asked to leave the courtroom and go to the jury room. During your absence, I will listen to the arguments of both the attorneys for the defense and for the prosecution, and thus make a decision as to the admitting of certain evidence. As for your duties here in this court, it is essential that you understand that nothing presented here in this courtroom is a fact until you find it to be so. It is thus necessary that you form your own opinion of the witnesses who testify here in court. Some witnesses may impress you as worthy of belief, and some may impress you the opposite. You should bear in mind any interest a witness may have in the outcome of a given case. That is, whether a witness will benefit in any way if a case is decided one way or another. There may be inconsistencies in a witness's testimony. You can usually disregard that fact that it may arise. Witnesses have only their memory to rely on, and as you all well know, it is easy to make a mistake in recalling something that happened even yesterday. To tell a deliberate lie or a falsehood is another matter. It has a serious effect on the entire credibility of the witnesses who tell it. Thus, you should listen very carefully as each witness testifies. Consider the demeanor of the witness on the stand. Also, you should bear in mind that a witness may be nervous not from telling of a lie, but because of being in a courtroom and because of the unknown surroundings. Besides the oral evidence presented, there will be other evidence. This will consist of papers or photos or other tangible evidence which are referred to as the exhibits. These you will have a chance to view as they are introduced. They will accompany you to the jury room where you will take them for your further scrutiny. The only things that should be taken into consideration are the things which are given as evidence in the court. Anything you may have read or heard about this case should be erased from your mind if possible. You must make a decision as to the guilt or innocence of the defendant solely from the evidence presented in this courtroom during the trial. You must not discuss the case with anyone outside of this courtroom, nor must you let anyone discuss it with you. If anyone tries, you should not listen to what they have to say. If they continue to try to discuss it, you should report the fact to me, and I will take care of the problem. The law is severe in dealing with anyone who attempts to discuss a case with a juror who is sitting on that case. Be especially vigilant in not discussing the case with your family or friends. They will naturally be curious about the case, and you must not accommodate their natural curiosity. You should simply inform them of my charge in this regard and that you have been strictly forbidden to discuss the case with them by me. You should try to keep an open mind if possible until all the evidence has been presented. It is essential that you not make a decision or reach a conclusion which is not based on all the evidence in the case. You should not discuss an opinion you may have about the case with a fellow juror because you retired to deliberate. Some fact may surface at the very end of the trial which may change your mind entirely and change the situation entirely. When you retire to consider your verdict, you will have heard all of the evidence and the arguments of counsel as well as the instructions on the law. That will be the time for you to discuss the case, but not until then. You are prohibited by the criminal code from disclosing anything that takes place with respect to this trial and the evidence while you are in the jury room. Disclosure of such facts would be a serious offense. It is essential that the community as a whole be convinced that there has been a fair trial. Thus, your conduct while sitting upon this jury must be above reproach. Your foreman or forewoman will be responsible for talking with me if it becomes necessary for you to do so. If you wish to convey something to me, write your message down and have the foreman or forewoman deliver it to me. I will do my best to accommodate any requests or questions that you may have. You should talk among yourselves only in the jury room. You should always listen to the opinions of your fellow jurors, even if they are all in agreement and you do not agree with them. However, if after hearing all the reasons for their beliefs, if you still have a different opinion, you should stick. And then we'll get ready for your Q&A. Mhm. I like carrot juice.
Just don't drink too much because you'll turn orange. You're electric.
And let me see you all. Oh, I think we got pushed record. This starts in the middle, but it is just practice, okay? Shirley, do you want to waive your right to read and sign the deposition?
Yes,
Would you please state your full name for the record
Shirley Ann Hunter,
and your current work address?
2450 North Causeway Boulevard, Suite 223.
Ms. Hunter, what is your profession?
I'm a vocational consultant.
And it's I think you've handed me a curriculum vitae. Let me just run through it real quick. You obtained your bachelor's degree from Southeastern Louisiana
Yes,
and then an educational degree from Tulane University in 1975.
yes,
Did you also attend the University of New Orleans in an administrative management position?
in adult education, yes.
And you also received a degree, I see, from Loyola University in 1987.
Not quite. I began the MBA program in 1987. I will finish this year.
Your primary area of expertise is what?
Disability case management from a vocational standpoint.
Can you briefly run down some of your work experience, if you could?
I've worked in private disability management since 1990. I work at this time for American Services. Prior to that, I was employed with Crawford & Company and also American Rehabilitation Consultant Services.
I see that American goes back to 1990, you said?
Yes, it does.
Since 1990, your primary area of emphasis has been, and then you have on your 225 Q&A, Mary Hargrave, Church Street, Apartment C, Houma, Louisiana, Lafayette Street, Houma, Social Security, State of Louisiana, Marksville, Nelson Smith, Time Saver, Barrow Street, Bond, TV, David. And it starts at the very beginning. This is going to be 225 Q&A for your mock. Could you state your full name, please?
Mary Hargrave,
What is your address?
3792 Church Street, Apartment C, Houma, Louisiana.
How long have you lived at that address?
3 years?
Were you living there at the time of this accident?
No, I was not.
Where were you living at the time of the accident?
I was living on Lafayette Street.
And that's in Houma also?
Yes, it is.
How long did you live at that address?
I lived there for 2 years.
How close is that to the site where this injury and accident occurred?
That is about 4 or 5 blocks, something like that.
Do you have a driver's license?
No, I don't. I don't drive.
And that's what I was going to get into. It was my understanding that you walked because you didn't have a driver's license. Is that right?
Yes, I walked.
At the time of this accident, you were not working.
I was babysitting for my sister 2 days a week.
What is your age?
I am 40 years old.
What is your date of birth, ma'am?
January 3, 1955.
Are you from Houma?
Yes.
What is your social security number?
I cannot remember it.
Other than this lawsuit, have you ever filed any other lawsuits?
No.
Have you ever been arrested for anything?
Yes.
Can you tell me what for?
I was arrested for forgery 7 times.
Would that all have been in the state of Louisiana?
Yes.
Just for clarification, it is my understanding that you were arrested once, but it was 7 counts.
That is right.
When was that?
December of 92.
What occurred? Did you plead guilty or did you go to trial on that?
I pleaded guilty.
And I believe you had to go spend some time in jail.
16 months
Where did you spend that at?
in Marksville.
Other than this accident, have you been in any other accidents?
No.
When I say no accidents, let me go through some various scenarios and tell me yes or no.
Okay.
Auto accidents,
No.
other slip and falls. I call this a slip and fall. I guess it can be disputed whether it was actually a slip and fall, but other occasions where you may have fallen and injured yourself.
No.
You haven't been involved in any workers' comp cases?
No.
Have you ever given a deposition before?
No.
This is the first time?
Yes.
Excuse me, I'm kind of jumping in and not letting you answer yes or no and not paying attention sometimes. So bear with me also. Your attorney has explained to you what takes place here.
Yes.
I just want to know the facts of the case, what occurred on that date, and I want to know facts about your injury, okay?
Okay. It happened on July the 23rd.
Okay, I'm going to ask you about it.
Okay.
I just wanted you to understand the rules here.
Okay.
If you don't understand a question that I asked, let me know and I'll try to repeat it or rephrase it.
Okay.
If you answer the question, I'm going to assume that you understood my question.
Okay.
Let's get into the facts of this accident. Do you know the day it occurred?
It happened on July the 23rd, 91.
Were you with anyone?
I was with Nelson Smith.
Is he just a friend of yours?
Yes.
Where were you coming from?
From my house. We was going to the store.
Which store were you going to?
The Time Saver.
Where is that located?
That's on the corner of Barrow Street and Bond.
The two of you were at your residence before you began to walk.
Yes. We was leaving from my house. Yes.
What were you doing at your residence?
We was watching TV and stuff. That's all.
Had you consumed any alcohol?
No, nothing.
Do you drink?
A beer every now and then. That's it.
What occurred?
We was crossing the street to go to the Time Saver, and when I got up on the sidewalk, I went down in a hole. And it was dark in that area, and they didn't have no light in that area. And when I went up on the sidewalk, my feet went in a hole, and I fell forward.
The area was not well lit,
No, it was dark in that area.
and you were going to cross the street, right?
Yes, crossing the street.
Which street would you have been crossing?
I was crossing in front of the funeral home.
Do you know which street you would have been attempting to cross?
It was David.
Had you walked in that location before?
Yes,
How often?
but that was in the daytime.
How often had you walked in that location before this accident?
A couple of times.
It was just twice.
Yes, a couple of times. Most of the time I'd be on the other side of the street, but at that time we happened to be on this side, and it was at night, and it was dark in that area.
So you've only walked on that side of the street 2 times before this accident.
Well, like I said, I would usually be on the other side. I never would be on this side here. I usually cross over when I get to the corner.
I understand that, but I'm trying to get a number of the times that you would have walked on that side of the road earlier.
Well, about 4 or 5 times. A couple of times, I would say.
But that was during the daytime?
Yes.
Had you ever seen the hole before this accident?
No.
Had anyone ever told you about this hole before this accident?
No.
Could you describe the hole for me? What did it look like?
It was a big round hole, and it was deep because, like I said, when I fell, half of my feet went in there almost up to here, and I fell forward. When I got up to get on the sidewalk, my feet went in it.
What foot went in it?
My right.
How deep was the hole?
It was real deep. Like I said, it covered up to here on my feet.
And your entire foot went into the hole?
Right.
How wide is the diameter of this hole? Do you know?
About like 6 to 8 inches.
I'm going to show you a photo which was taken by an investigator for me and ask you if that is the hole.
Yes, that's the hole.
Why did you step in the grass to begin? Okay, you all. So that concludes your mock. Good luck. Have a great day. And remember, we have 2 mocks on Monday for your finals, okay? Speed build on your own.